My name is Carl Pearson. I'm an attorney defending against foreclosures. I sue banks for wrongful foreclosure and to obtain a loan modification agreement for my clients, and also to vacate judgments of foreclosure and sale based on newly discovered evidence. In this video number 51, I'm going to discuss how most or many homeowners who have already lost their homes through judicial foreclosure, whether that lawsuit was contested or not, that is, whether it was contested or went into judgment by default, have a good possibility of opening up or vacating the judgment of foreclosure through newly discovered evidence that has only recently come to light. Now remember this, what is, quote, newly discovered is taken from your standpoint, not mine. I may have learned about the evidence for several years, but you may not have learned about this evidence until recently, and perhaps through me or one or more of my videos. Here are the instances of newly discovered evidence I believe could be used in whole or in part to vacate the judgments of foreclosure and sale for millions of homeowners in the United States, perhaps you, who have lost their homes through foreclosure, and enable the homeowner to get back his home or obtain damages for wrongful foreclosure. The statutes exist in New York, for example. The New York CPLR 5015 provides for newly discovered evidence. Many of the state civil procedure codes are based on the federal code, and Rule 60B in the Federal Rules of Civil Procedure provide a basis for opening up a judgment for newly discovered evidence. In Florida, the rule is in the Florida Civil Code. It's 1.540, and in the California Code of Civil Procedure it's sections 472 and 473B. Now, here are the instances of newly discovered evidence I believe could be used in whole or in part to open up judgments, whether by default or not. 1. That the bank did not own or possess the original note at the time of foreclosure. 2. The bank or MERS destroyed the original note, and that's called willful spoliation of evidence, and there are sanctions for that. 3. The bank failed to comply with the state law requirements for a foreclosure action, including the use of fraudulent affidavits and the failure to review the documents before commencing the lawsuit. See the 27-page Attorney General Settlement Agreement, which is on my website, carlperson.com/agreement.php. 4. The bank had a deceptive fraudulent loan modification agreement program designed not to give a modification agreement, but to lure homeowners into default and loss of their home through foreclosure, the dual track of foreclosure. 5. Breach of contract by the bank and breach of the implied covenant of good faith and fair dealing by reason of their fraudulent loan modification dual track program. And there are probably other matters that could be raised, but you want to only raise the most important ones that apply to you. And this is a way of obtaining possibly a recovery of your property, because about half of the foreclosed properties are still under control of the banks that foreclosed. So there's a good possibility, and in any event you have a right to damages for wrongful foreclosure. The cost is really inexpensive, and I have a video on that. My name is Carl E. Pearson. I can represent you in obtaining recovery through newly discovered evidence for the illegal activities involved in the foreclosure and sale of your home. I can represent homeowners anywhere in the U.S. by using local counsel in states other than New York. You can call me for a free consultation at 212-307-4444, or send an email to me at carlpers2@gmail.com. That's carlpers2@gmail.com. It's a number 2. Once again, my telephone number is 212-307-4444. I look forward to speaking with you. Don't be afraid to give me a call. It doesn't cost you anything. Thank you.